State's response.
If it pleases the court, I think what we've heard over the course of the last 30 minutes underscores two equally compelling notions. Number one, talk is cheap. Anybody with a computer or a word processor can say anything they want to in a plea without any evidentiary support and do so with a straight face. And number two, no good deed goes unpunished. Let's start with how no good deed goes unpunished. I think if Mr. Schaefer and I had to rewrite history and relive what happened back in July, we would have treated this defendant the way any other criminal defendant who's indicted in this building should have been treated. How? Exactly what Gail Ligo said. When a true bill is handed up, a warrant issues, if the defendant's not in custody or on bond, he's arrested. They go to great lengths to talk about how Judge Olner allegedly publicly humiliated Mr. Paxton by issuing arrest warrants, but of course they don't talk about the fact that those warrants never entered into the system. Can you imagine how we'd be dealing with the allegations they would raise if we had treated Mr. Paxton as any other defendant, entered those warrants in the system, and had Mr. Paxton arrested by members of his own security detail? This is a situation, Judge, where they wanted special treatment. They may not acknowledge it now, but Joe Kendall, who was once sitting where they sit, got with Mr. Schaefer and decided that because of who this criminal defendant was, they were going to get a bunch of breaks that few, if any, defendants who were indicted in this building ultimately get. A voluntary surrender, a booking process that lasted less time than the Seinfeld episode, being driven through the booking process in a blackout van, PR bonds on 2 first-degree felonies. Again, they dictated at the time how they wanted this to all go down. So when we talk about things like why Judge Olner held on to the indictments, why? Because that's what they wanted. And the fact that there's some skullduggery because Judge Olner took a grand jury out of term from Judge Scott Becker, well, I think everybody in this courthouse knows that Judge Becker is undergoing chemo treatments for cancer, and it stands to reason that in the midst of that treatment, perhaps he didn't want to burden himself with yet another administrative task, even though he was the administrative judge. What they're essentially doing is taking a number of errors that are anything but, and asking this court to accumulate non-error, which the case law says they can't. Because at the end of the day, for you to hand him, once again, another extraordinary pre-trial windfall, is to basically believe that they've shouldered their burden, that there was some Machiavellian plot by a dedicated public servant, Judge Chris Olner, a plot that would probably make Oliver Stone's eyes roll, that everybody involved in this process, Judge Olner, his wife, Mr. Schaefer, myself, and most of all the grand jurors, were in on their little, as they put it, not-so-secret mission to indict Ken Paxton. And one of the building blocks that collapses like a cheap suit is that the people who were impaneled in the 416th grand jury back in June were just chomping at the bit to indict this criminal defendant because of these headlines that were apparently permeating the Metroplex. All of which, as they would say, begs the question, how did the 416th grand jury even know that they were going to hear this case? They didn't know anything about it until we decided to present to the grand jury on a Tuesday, because Tuesday happened to be more convenient for us. Their entire presentation is speculation, Judge. It's what if, maybe that. But it's telling that the one witness who could have filled in the blanks on the canvas that constitutes their burden, not ours, their burden. It is their burden, and it is extraordinary. Why? Because they're looking for a bonanza prior to any juror ever being impaneled in the trial of this case. And the law says that's a Herculean burden. So they called Gail Ligo. And again, say what you want, but at the end of the day, I certainly think she gave the state of Texas more than she gave the defense. Why? Because she basically goes through each of the allegations that constitute this illusory scheme by a dedicated public servant to indict this man and tears him down one by one. But this is what matters, Judge. They've got the same subpoena power we did. And if they had wanted to subpoena Chris Olner and have him take the stand, they could have done that, and they didn't. Why? That's their burden, and they haven't met it. So let's go through each of these alleged claims of error, because at the end of the day, the presentation tanks. The notion that sealing the names of the grand jurors interfered with their independence, it didn't impact their independence. It protected them. How could it have possibly interfered with their independence? And when we recognize what happened to Judge Tucker's grand jury, the first grand jury to whom Mr. Schaefer and I were introduced back in April, when you realize that that grand jury had been approached by a blogger or wannabe Pulitzer Prize winner, whomever it was, just rolling up on them in the parking lot or contacting them at their home or place of business, Judge Olner had every reason within his judicial discretion to seal their names. And the Attorney General opinion they rely upon, and by the way, with all due respect, Attorney General opinions are a rank below, I don't know, corpus juris in terms of presidential vitality. That AG opinion doesn't stand for the proposition that Judge Olner did not have discretion to seal those names, because the opinion expressly says we don't reach that issue. And how were they harmed? They ultimately realized who those grand jurors were, so they could present the very speculation-laden conspiracy theory that they present today. And just one word about the notion of the improper impanelment, because, again, I think Mr. Coggle's presentation was certainly outstanding and to the point. Volunteers are not the essence of arbitrary as they want this court to believe. Why? Because, as Ms. Lipo told you, being a grand juror in Collin County is a big deal. You serve for 6 months, you may serve all day, and once you start, there's no stopping. And it's because of that, when you look at it through that prism, that you realize that volunteers, once they've been pre-qualified, once you recognize that they meet the statutory qualifications, and we're going to waste time and ask them again, once they've been qualified, once they show that dedication, that is a process that enhances, fortifies the integrity of the impanelment process. It doesn't detract from it. Gail Lico said she didn't know whether or not this grand jury was deliberating when Judge Olner walked in there. It stands to reason, Judge, and again, this notion that he was in there for 45 minutes that Mr. Hilder says, I'm not sure where he gets that from, but if he wanted to subpoena Judge Olner, he's right upstairs. Instead, they tried to make a record from Gail Lico that ultimately eviscerates their claim and doesn't enhance it. There is no rule, regulation, case or statute that somehow says it's illegal or unlawful or just not right for a judge to enter a grand jury room so long as they are not conducting proceedings. They don't need a transcript of what went on in there. They could have gotten whatever they think they need from that transcript by subpoenaing Chris Olner, and they didn't do it. Again, why did Judge Olner hang on to that indictment for 3 weeks? Because that's exactly what this defendant, his then lawyer, wanted. Why? Because Joe Kendall was out of town, he couldn't be bothered, and because this defendant was in Hawaii on vacation. Imagine how that would play in the court of public opinion if we had done to this defendant what every other defendant would have had done to him. The notion that we concocted a 90-minute window within which these allegations weren't made public, well, again, you're not going to hurt my feelings, Mr. Hilder, but I think that that allegation is the ultimate piling on. Why? Because the facts tell a different story. Because why, as Churchill says, the facts are stubborn things. And what happened was, when that indictment was handed up, it was processed in the way of any other indictment that the code permits to be handed to a district judge, consistent with what this defendant and his lawyer wanted at the time. But when Judge Olner and the Rangers and myself and Mr. Schaefer were gathered around the bullpen upstairs, there didn't seem to be a reason not to seal those indictments. Why? Just because. So for a 90-minute period, when Judge Olner left, those indictments, as far as the free world was concerned, were not sealed. Now, what happened when Judge Olner went home and told his wife was clearly in good faith, not bad faith. And as soon as Sissy Olner recognized that those indictments were not public, she did everything she could to try to mitigate the damage after she had communicated with someone who she thought was a good friend. And again, those screen captures, titillation that ultimately doesn't add up to anything other than how this is going to play tomorrow in the Dallas Morning News on the front page of the Metro section. Ms. Lycos made it clear that whatever happened when Judge Olner entered the grand jury room, again, as far as she could tell, they weren't deliberating, they weren't voting. He certainly had every right to be in there. And again, the cases they cite aren't to the contrary. The fact that Judge Olner may have ultimately entered, and again, as Gail Lycos pointed out, the grand jury didn't know that I was going to be there that morning. They hadn't been told about the prospective special prosecutors. And so it made sense at that point to let the grand jury know who this guy was coming in from Houston with his 2 Texas Rangers. Again, it's illusory. It just doesn't add up. The fact, again, that warrants were issued, if they're not entered into the system, how can you possibly be harmed? Had they been entered in the system, which I suppose now is what they claim that we should have done, again, any peace officer, including this defendant's security detail, ultimately arrested him, and God knows how that would have played in the court of public opinion, according to them. The violation of grand jury secrecy that they make so much about, and again, segueing back to Judge Olner and his wife, at that point, there is no showing that Judge Olner violated grand jury secrecy. When he turned to walk away, as far as he knew, there was no reason to seal those indictments. It was only after those indictments were sealed, at their insistence, this entire cut from whole cloth narrative begins to reach critical mass. And again, the fact that these indictments had even been discussed, that grand jury secrecy had been compromised. And again, this is the same nonsense that we see in the motion attacking Mr. Schaefer and I for allegedly violating grand jury secrecy. The provision in 2022B about indictments not being made public certainly applies, and the legislative intent reflects, dating all the way back to the 1880s, to keep a defendant from running, as we recognize that Ms. Lycos acknowledged as well. If at the end of the day, this defendant had fled to Costa Rica because somebody had mentioned the fact that these indictments had been unsealed, yeah, we'd have every reason to be calling for their heads, only that didn't happen. Finally, they've made a lot of allegations. And I think that it's not surprising because, as anybody who's ever taken a journalism course recognizes, great storytelling not only requires a protagonist, somebody who overcomes everything in the third act, a bad guy. And in this case, based on this motion, not to mention the remaining motion that we're going to talk about in a minute, this defendant's gone out of his way, needlessly and cruelly, to cast a number of people as villains and villainesses without any cause, without any proof, without any basis in fact. Who? Judge Olner, a dedicated public servant who has served the citizens of this county for 2 decades as a jurist and prosecutor. His wife, who's collateral damage. But more importantly, grand jurors. Because if you buy into what they're trying to sell you, Judge, you have got to believe that these 12 grand jurors selected at random from all across this county were in on it. That they were dupes, they were pawns of this Machiavellian scheme that Judge Olner had to indict this defendant. Shame on them for throwing those grand jurors under the bus. Shame on them. And it's not that they stop there, because in one of the allegations that they haven't reprised today is at page 15 of their original motion, where they say, quote, "The only conceivable way Ms. Olner could have learned about Paxton's indictments was through her husband, Judge Olner, who presided over the grand jury and somehow arranged to have Paxton's case assigned to his trial court." They stand in the well of this court and for some reason are backing away from that argument. I don't know which of these guys was responsible for that. This is a great team. This This is a terrific team. This is the 1927 Yankees murderers row. These are the best lawyers in Texas. But whoever put that into motion, it's beneath them. It's just wrong. Why? Why would you accuse Chris Older of engaging in one or possibly two felonies when their own exhibits attached to their motion reflect this case was randomly assigned? There's no way around that. You know, he claims, again, that Judge Older issued the arrest warrants to publicly embarrass and humiliate Paxton. Again, Judge, I think we know the facts tell a different story. Why? Because it's exactly what this defendant and Joe Kendall wanted. And again, they claimed in other pleadings that they've kind of walked through that I think it was in relationship to the judicial estoppel argument in one of the cases. How dare we, as special prosecutors who generally make a living as criminal lawyers, put a defendant in a position of not being able to mount an effective defense to be afforded those rights that somehow, as criminal defense attorneys who cherish that panoply of constitutional rights, we've kind of forgotten about them as special prosecutors. Make no mistake, this defendant, and any other defendant, but particularly this defendant, is entitled to every conceivable constitutional right imaginable. You talk about the effective assistance of counsel, this is it right here. A fair trial, a reliable result, mutual and detached jury that, again, we are a year away from seating. He's got the right to every one of those constitutional protections. And his defense team, as terrific as they are, have the right to make any credible argument that's fairly supported by the evidence, and even those that are somewhat novel. But you are not entitled to play to the base like you're on the campaign trail, by throwing people under the bus at random, whether it's Chris Oldner, or whether it's his wife, or whether it's those 12 grand jurors that did nothing more than do their jobs, who took the oath not to indict or present out of envy or hatred or malice. You're making them co-conspirators in this grandiose plot that somehow just simply doesn't exist. You are not entitled to needlessly trash public servants, their spouses, and members of the grand jury. Because when this court denies this motion, as I know that it will, the damage is done. What's happened in this courtroom is going to live on in the ethernet of Google searches and petty partisan postings on people's Facebook walls. You know, Mark Twain said that a lie can make it halfway across the world before the truth can put its shoes on. I don't know about halfway around the world, but when these statements, particularly that salacious low about Judge Older having these cases assigned to his court, didn't make it halfway around the world, Judge, but it's made it throughout this courthouse, this county, and this jury panel. And when this court denies this motion, that stops.
Yes, Judge. Counsel engages in fiction. What I heard was a fictional recitation. I guess it's because he likes quoting Animal House or Mad Men. He lives in a world of fiction. That motion that we filed with this court is based on fact. This court can take a look at it. It's well sourced. We have documents from the district clerk's office. We have texts from Ms. Older. In fact, he talks about, oh yeah, Judge Older went home after the return of that grand jury indictment. Well, I'll tell you, I think that grand jury indictment was returned a little after 4 o'clock. The first text from Ms. Older is 3 minutes later to Susan Fletcher, knowing that Mr. Paxton had been indicted, hardly going home and just having a random conversation with her. She knew right away. It would be very peculiar, I suppose, somebody working, let's say, in the Pentagon, who gets some information and before he walks over and gets it stamped confidential, calls, the justification, calls his wife, hey, I know these troop movements of ISIS, and let me tell you where they're at. Now it's stamped confidential, I can't talk about it. No, Judge Older knew from the moment that return of that indictment that matter was confidential. He knew he could not communicate that. And yes, unfortunately, there are ramifications for grand jury secrecy. There are matters in which the court could move for violations of grand jury secrecy. But it is a concoction and we'll treat them like everybody else in this courthouse cases. Counsel knows very well that unless somebody is really a danger to the community or a flight risk, they're probably entitled to have a summons. And that the law provides that a summons shall issue if the prosecutors had asked for that. Mr. Paxton is a well-regarded member of this community and a well-regarded elected official. And to have it any other way than a summons would be improper. And so if counsel's saying, hey, on his way out the door upon recusal, the judge issues these 3 cases, but it's okay because they weren't entered into the system. No harm, no foul. No. Why do you even do it in the first place? Don't know. Why? Don't know about the system, but we do know that they never should have been entered into, and he did it on his way out the door. Again, everything that we have specified is well sourced in this motion of ours. In terms of the witnesses, saying that, Gail Blake has testified that the grand jury wasn't deliberating. Again, it's changing the conversation, which counsel likes to do. We're not talking about deliberations. We're talking about proceedings. Proceedings are when the grand jury is meeting. The grand jury is meeting between locked and closed doors that nobody has access to. That's a proceeding. That's when the grand jury was meeting. And the grand jury was meeting, they were in proceedings, and the law specifies of certain people that can go into that grand jury room. And Judge Holder does not qualify as an individual that is entitled to go into that grand jury room. Not once, not twice, not at all. Talks about, I guess they had a prior agreement with Mr. Kendall to allow the holding of the July 7th indictment. Sorry, he can hold it. I don't think Mr. Kendall knew, number one, that indictment was being held. And in fact, as we saw from communications from Mr. Schaefer, there was supposed to be a meeting where I think Mr. Paxton was going to have to turn himself into court date, I believe it was like August 15th. So we're talking about, 6 weeks after July 7th? So it's very disingenuous for counsel to say, we were doing this as a courtesy because Mr. Paxton was on vacation. So Judge Older was going to hold on to the indictment. No. First of all, I am quite confident that Judge Kendall did not know that that indictment was going to be held without being put through the proper rotation. As this court knows, that you can still have a sealed indictment going through the clerk's office. It remains sealed, as that July 28th indictment was supposed to be. It's held until 2 things happen, really, until a habeas is issued or the person's in custody, or unless there's like an agreement to have a summons, maybe 3 things. But it can be held. The fact that he argues that Mr. Paxton's prior counsel was okay with Judge Older circumventing state law, circumventing the clerk's office, and holding on to an indictment for 3 weeks without it being assigned to a judge is completely and utterly disingenuous. He knows that that's not the case. He talks about us slighting the grand jury. No. We're not slighting the grand jury and good people that comprise the grand jury. What we have a problem with is the process. Counsel talks about the good nature of the judge and how this motion, tars and feathers the good name of the judge and some others too. This motion sticks to the facts. This motion is well sourced. And what about the good name, the good reputation, and the good public servant that we have here, Mr. Paxton, too? He's entitled to have a fair and impartial judge and system, and that was not afforded to him. And they can call it error, they could call it mistake, they can call it anything they want, but it combines to come up with the totality of the circumstances that shows that there was not impartiality in the judiciary. Thank you.
Mr. White.
Judge, very briefly, I appreciate Mr. Hilder's attempt at letting the court know what I know.
Well,
I'm a lawyer.
if you have a case, I was working with it.
Okay.
I think you walked right into that one, didn't you?
I've been a lawyer for 34 years, Judge. I've never seen a summons in a felony case. I don't know how they do it in Tarrant County. I know how they do it in Harris County. I can't ever remember a summons being issued that now Mr. Holder says is the rule and not the exception. So Judge Older called his wife a couple of minutes after these indictments were handed up, but not yet sealed. Again, what's the harm? What's the case that they decided? And again, there's been a lot of rhetoric and a lot of heat with very little light. A case, just one. Just one case that says they're entitled to be handed a get out of jail card. Doesn't exist. Troop movements? Seriously? National security? Come on. I think if you make that argument, you better be prepared to defend it, and they can't. Judge Omar had every right to keep that indictment after it was handed up in his possession. Why? They were just doing what Joe Kendall wanted them to do. And there's been a lot of talk over the last couple of minutes about what Joe Kendall knew or what he might have known. Again, they've got the same subpoena power we do. I haven't seen Joe Kendall. As opposed to the facts according to Mr. Hilder, I think we probably would have been better served and they would have shouldered their burden by calling not only Judge Olner, but Judge Kendall as well. You know, they talk about changing the conversation. No, let's talk about shifting the burden. It's their burden, whether it's in the context of the pretrial that they filed or the motion to quash based upon this illusory misconduct by a dedicated public servant. It's their burden, and it's extraordinary because it seeks to terminate these proceedings before the first juror is ever sworn or the first witness is ever called. And they can spin it any way they want to, but they are essentially telling this court that this grand jury violated their solemn oath to indict only upon probable cause and not out of envy or hatred or greed or any of the other considerations that the Code of Criminal Procedure speaks of. I don't think we live in a world of fiction or fictional characters and sound bites. Our responsibility under 2.01 of the Code of Criminal Procedure is not to convict but to do justice. And the fact that they have sought to spin the conversation away from that by attacking us personally, I think speaks volumes, number one. But number two, if they had a witness who could have testified that Judge Olner had these indictments assigned to his court, again, which comes within a heartbeat of one and probably two felony instances of misconduct, I think we would have heard him or her. That didn't happen. I think it's smoke. I think it's mirrors. I think it needs to be denied.
Very briefly.
Very briefly, Judge. Counsel talks about the harm. What's the harm? Well, let's take a look at that July 7th indictment. What's the harm there? You know, about the registration issue. What's the harm? There is no harm there. They're saying that there doesn't need to be harm. There just needs to be a violation. There's a violation here. There's a violation of grand jury secrecy. He also talks about, Judge Kendall. This is the way he wanted it. Judge Kendall, as reflected in one of their exhibits that they filed, I believe it's like a July 30th letter that Judge Kendall had sent them, recounts a conversation that they had a few days earlier with Mr. Schaefer. Judge Kendall did not know that Mr. Paxton was indicted until about the third week in July. And so it's not like, oh, let's hold the grand jury indictment from the 7th to accommodate Mr. Kendall. Mr. Kendall did not know about that indictment until 2 or 3 weeks later. So I think, again, being very disingenuous on their part. And the court can take a look at the memorandum, if you would, in one of their exhibits of the letter that Judge Kendall had sent to the special prosecutors memorializing the conversation that they had, which reflects that Judge Kendall did not know that that grand jury issued the indictment on July 7th at the time.
Okay. What do we got next?
Can I have just a moment?
Yes, sir.
time, we would bring up the motion quashing indictments on grand jury abuse by the special prosecutors, but we'll rest on the briefing that we've already submitted.
You'll submit that on the motion
Yes, sir.
and everything that's attached to it.
Yes, sir.
State submit their response on the state's answer.
We do.
Okay. Thank you.
And just for clarification for the court, there's a chart that we believe that is an attachment. I believe it's attachment A to the response, and it has different categories where we believe the violations are. We left them blank, so it would be an aid to the court to go through the different statements and make a determination whether they were a violation of which provision within the Code of Criminal Procedure. So it's just an aid to the court.
Okay, so because when I got these from council by emails, I may have gotten some of the exhibits mixed up, and I know that in one of the motions, there is an Exhibit H that you've mentioned, or is it Exhibit A? I'm sorry. Okay, let me see to make sure I have what Exhibit A.
It's approximately 5 or 6 pages. It is a conglomeration of various quotes by the attorneys pro tem and the dates of the quotes. And if the court doesn't have it,
I was going to say I do not, and so, or I may have mixed it up in one of the other motions. If you'll email it to me tomorrow,
yes, sir.
that'd be great.
Yes, sir.
And I'll put it in with the motion. Is that agreeable with the state?
Sorry, Judge,
They have apparently a Exhibit A that is attached or made part of their motion quash indictments because of the Attorney Pro Tem's disclosure of grand jury information in violation of grand jury secrecy that I either did not get or I have it mixed up, and I'm just asking, could they email that to me tomorrow?
Absolutely.
Okay, that's great. Thank you.
I'll do the same with respect to my PowerPoint.
Oh, thank you. And be sure to send a copy of the PowerPoint to the state.
I would.
Okay. All right. If I'm keeping up with everything, I think we're down to motion for leave to file additional motions.
Should we coin flip that one, Judge?
I was going to say rock, paper, scissors.
Judge, if it'll expedite the process, the state has no objection.
That is the one motion I will grant. No, not to be, I'm going to do that right now is what I'm saying.
We understand.
Okay, so is that the defense and the state's understanding of all the motions that needed to be heard and presented today?
Yes.
Yes, sir.
Okay.
It is, Your Honor.
I had previously mentioned to council a proposed time frame for me to rule on these before we came out, but I think I'm going to wait until I receive the defense's response to the state's motion for leave to file the indictments, and then I will issue rulings on all of those motions. I will need to know when you file your answer to the state's motion for leave to amend, if you're going to wish to present them here in court. Would you wish to present them by telephone conference, or do you wish to submit them on the motions themselves? And so I will wait until I hear back from y'all. Is that agreeable with the state?
It is, Your Honor.
And that's agreeable with the defense?
Yes, sir.
Counsel, I cannot thank you for working hard and working diligently and showing me a lot of courtesy. With that, we are adjourned. Thank you.
Thank you.
And it's going to take me a while to pack up, so y'all can disperse.
Thank you.